Hey everybody. I hope you're having a good evening. Um, I'm about to keep studying for the bar. Right now I'm working on defamation and privacy. And what I've been doing in my streams has just been kind of thinking out loud. I'm going through a study guide that's like 100 pages, and I'm going through and reading it, and then I'm just taking notes on screen. And it helps when I put the what I'm reading into things that are not legal language. Um, and so I wanted to go ahead and try that out. So if you hear me like stop or pause, it's just because I'm reading and processing. And if you have any questions, feel free to let me know in the chat. I just graduated law school, and right now I am studying for the bar. It's very boring to do by yourself, so I decided to try to hop on here. I'm also a tutor, so the teaching part of me kind of comes out naturally when I'm studying. But if you have any questions about law school, about studying for the bar, anything at all, feel free to ask in the chat. Otherwise, I'm going to go ahead and get started. Okay, so let me rearrange my screen. Oh, hey, Alap. I'm really excited for this one for defamation and privacy. So I think this is a really good one to listen to. I think that I feel like people in our group would think this was interesting. Okay, perfect. Let me rearrange my screen here. Okay, got it. All right, so let's talk about what you need for defamation, to bring an action for defamation. So you need so defamation is language that is three things: of or concerning the plaintiff. It's published to a third party who understands it's defamatory, and it damages their reputation. Okay, it's of and concerning of the plaintiff, published to third party who knows it is defamatory, and it damages reputation. Okay. For matters of public concern, okay, I don't think I'm going to write this down yet. Okay, so what is defamatory? Defamatory just means harming a person's reputation by diminishing respect, esteem, or goodwill, or deterring others from associating. Okay, so let me put this here. Who knows this is defamatory? What's defamatory? What did I just say? It diminishes reputation through respect, esteem, and goodwill, or deters others from associating with them. And if you hear me like talking slowly, it's because I'm reading and then I'm looking away as I'm typing just to make sure, like, did I memorize this? Okay. So what does it mean to be of or concerning the plaintiff? That means a reasonable person must believe that the communication refers to that person. What the heck does this mean? A reasonable person must believe that a defamatory communication refers to this particular plaintiff. Okay, I had to break this up. So, reasonable person believes it's about plaintiff. And it holds the plaintiff up to scorn or ridicule. Jeez. Okay, so to be of or concerning the plaintiff, a reasonable person has to believe it's about the plaintiff, and it has to, I don't know, invite scorn and ridicule. And what else? To a substantial number of respectable members. Substantial number of respectable members of the community. Okay. A deceased individual cannot be defamed. That is good to know. Must be living. Okay. I think I kind of knew that, but I never really thought about that. Defamed if the language. Okay. So for it to defame a business, it has to prejudice the business. Okay. Prejudices, meaning just like makes it more difficult. Well, I think I should probably just write it. Harder to conduct activities or deters others from dealing. Okay. What is publication? Publication of a defamatory matter, okay, is the intentional or negligent communication of that matter to a third party. Isn't that what it's kind of what I just said, I thought. When did I say that? Okay, I did say that. Okay, but publishing means intentional or negligent communication. Got it. Okay. The bar exam often, okay, whatever, I'm not going to read that. A person who repeats a defamatory statement may be responsible for defamation, even though that the original person, the original source is identified. And that person, so you might be liable for defamation if you repeat a defamatory statement, even if you're not the source and you don't have knowledge of the truthfulness. So I'm assuming that that means if you negligently, and negligently here means with like reckless disregard, I think. I wish I had said more about that. What is that? Okay. I'm getting myself too stuck in the weeds here. Okay. Publishing, intentional. Got it. All right. So let me go over what defamation is without looking at the screen. Defamation is a statement that is of or concerning the plaintiff. The plaintiff has to be living, and statement has to, a reasonable person has to believe it's about the plaintiff, and it has to hurt their reputation by diminishing respect, esteem, goodwill to a substantial number of respectful members of the community. The second element is the statement has to be published to a third party, and published, and the third party has to understand that it's defamatory. So that means it has to be either intentionally or negligently communicated to the third party, and the third party has to understand that the statement opens up that person to scorn, ridicule, and or deters others, I think. Oh no, I don't think that's right. Scorn, ridicule, and like deters others from associating with them, maybe. If it's a business, then it has to be something that prejudices the business's activities or deters others from associating with them. I think that was it. Oh, I did a good job. Okay. Nice. Oh, that hurt my brain. I'm really curious to know what you guys think, if this is like what you expected lawyer studying to be like, if it makes you, what makes you think about like what you see in like from lawyers in court. Because I feel like I feel like people underestimate how much we are trying to like how much we have to pay attention to in our writings. Even though obviously people know it's a lot, but I feel like it's a lot more than people think. I mean, yeah. Ooh, that was like a little bit of an adrenaline rush because I was really hoping that I remembered that. Okay. Great. Now, of course, there's more. But that's okay. There's always more. After this, I'm finally done with this topic, and then I start constitutional law, which was my least favorite class, my first year of law school. So I'm not excited for that. And if you're just joining, let me put up my defamation um, slide here. I graduated law school last month. Yep. And now I'm studying for the bar, and it helps to just talk out loud. And I figured some people would think it was interesting. I spend a lot of time on YouTube, and I know like defamation is something that comes up a lot on YouTube. So I thought this would be cool too if you wanted to learn exactly what defamation is. Again, this is not legal advice, and I'm making no guarantees that this is accurate. I'm pretty positive it's accurate, but I am not a lawyer. I am studying to be a lawyer. I will take the bar at the end of July. Okay, on to the constitutional requirements for defamation. Okay, defamation. So, okay, these are, give me 1 second to try to orient myself. Okay, I guess I'll just define these. Okay, so a public official in a defamation suit is, okay, substantial responsibility for or control over government affairs. Okay, whatever. Public figure. Public figure. There's two types of public figures. Public figure is treated as public official. And oops, I'm sorry for that loud noise. I hope that didn't scare anybody. There's two types of public figures. General purpose, who have persuasive power, influence, and deemed public figures for all purposes. And then the second type of public figure is our favorite type, a limited purpose. If you know, you know, limited purpose or special purpose public figure. The definition for this type of public figure is funny. A limited purpose or special purpose public figure is one who thrusts themselves to the forefront of a controversy, well, public controversy, to influence the resolution. Okay. So got it. Public figures treated as public official if the defamation relates to the controversy. I think I'll know what that means. Okay. What if you are a private person? So if you are a private person, and it involves public concern, an issue or matter of public concern, then you get limited constitutional protections. I'm already hating this. If you are a private person and the statement is not public concern, you have no constitutional restrictions, except most states have their own laws. Sure. Okay. What is a matter of public concern? Oh, that's not what they're going to tell me. Okay. My goodness. So if it's a matter of public concern, I'm going to have to reorganize these because the way I'm explaining it, I'm going a little slow, sorry. Because the way I'm reading this is, I do not like how this is organized. Okay. Man, I don't like the way this is organized. Okay, anyway. Defamation. Okay, so if it's a matter of public concern, or plaintiff is public official or figure, you have to prove plaintiff must prove statement is false. Okay, so if the statement is about a public person and a public issue, that person has to prove the statement is false just to even get through the door for defamation. Okay. At common law, some states today, a private person plaintiff suing for defamation regarding a statement that does not involve a matter, oh my goodness. At common law, some states today, a private person plaintiff suing for defamation regarding a statement. Okay, so some states, sorry, so if it's a private person and let's just say not public concern, some states do not require proving it's false. Okay. If the plaintiff is either a public official or public figure, then the plaintiff is required to prove that the defendant acted with actual malice. Oh my goodness, this is so messy. Okay. I think I need to do a slide for public, because this is not making sense to me. Okay. Defamation, public officials, figures, and concerns. And then the second slide I will make, because these are different rules, because there's the thing that's confusing me, and now that I'm thinking about it, might not be obvious. There's one set of rules if the person being defamed is like a public figure, versus a whole different set of rules if it's someone who is not a public figure or official. And then on top of that, there's a whole set of rules if the statement is about an issue that is important to the public, and then a whole different set of rules if it's a statement about an issue that is not public. And then if you mix and match those, you can get a lot of different combinations. So it starts getting very confusing. So make this one defamation of private people and private issues. And you might notice, like, I probably have typos and I'm not capitalizing things. And you actually see this sometimes with lawyers, like you just learn those things don't matter. Not when you're like turning in court papers and things, but when you're just trying to like remember stuff or jot down notes for yourself, and you're trying to get through it quickly, which I am, then you just keep going. Okay, so all right. Let me bring this here. Okay, so let me take this. Let me put it here. And let me take this. And I'll put it here, and then I'll go over these two slides that I just reorganized just to make this make more sense. Okay, yeah, I think that's going to make much more sense. All right, so defamation for, okay, if the statement defames a public official, then you have to prove that the statement is false. If the statement involves a public concern, you also have to prove that the statement is false. Okay, I think that is all I know so far. Yes, we'll get to more. All right, now, if he is a private person and a private issue, so two privates. So if it's a completely private issue and you're a private person, the states do not require you proving it false. Okay, let's keep going. So for a public official, all right, let me start a new slide here. That was not, I'm going to have to go back over that sometime, but okay. Defamation of public official, because I think this is actually what is going to be more helpful. All right, so it has to be made with actual malice, which means knowledge that it's false, or made the statement with reckless disregard for the truth. Okay. The plaintiff okay. Then must have had serious doubts about its truth. Okay. Now, if for defamation of a private person, it's a little bit different. Defamation of private person. You have to prove that it was said with negligence or actual malice. Okay, I don't know why they made that so confusing. All right, so for a public person, you can sue if it was made with knowledge that the statement was false. Well, okay, sorry. So if it's a public figure or official, you have to prove that it was made with actual malice. If it's a private person, then you have to prove that it was negligence or actual malice. Got it. Okay. Why is this so confusing to me? Okay. Public concern, private concern, negligence. Okay. So going back over this, defamation of public officials and figures in matters of public right? Matters of public concern. I'm gonna have to review this later. I'm gonna have to keep going. Okay. That was rough. That's a lot. When I'm doing, just to let you know, like how, at least how studying for the bar works for me, I'm doing torts right now, which are like things you take people to civil suit for like injuries, whether it's like financial injuries or like physical injuries, so like assault, battery, defamation, anything that's like not criminal but still harms. I have a 100-page outline, and it's like, of course, in really tiny font. And I read the outline, and there's videos and worksheets to go along with videos, and then I do a bunch of quizzes and essays and tests. So I have to remember that if I'm not getting it just reading, I'm going to see a video about it later, and I need to just keep moving. Okay, which is good that I'm going live too, because I know it gets boring if I'm just like staring at my screen reading. So it's good like to keep me accountable to keep moving, because there's more interesting things to come. Like, what is libel? Okay, let's talk about libel. So libel is defamation, written, printed, or otherwise recorded, and that includes TV and radio. Okay. Most and usually includes emails too. Apparently courts have not decided whether that includes social media posts and text messages, but I don't know. I would imagine probably most courts would think it does. Okay. So what can you get for libel? What are your damages? Which means like what? Well, yeah. Well, how much can you get? You can recover general damages to compensate for harm to reputation. Okay, now there's this special thing called libel per quod that some jurisdictions do, apparently, and it if you have to bring in outside facts to prove defamation, have to also prove your special damages or that it is slander per se. That's not going to be a big deal. I think this is just like a nerdy quote. A nerdy note. I'm not going to worry about the libel per quote. And I also, my book tells me like whether, all states do this, just some states do this. And that one was just some states. Okay, let's talk about slander. Ooh, I am happy to be away from that public figure and public concern stuff. That was really like frying my brain. Okay. So slander is defamation by spoken word, gesture. I wonder what slander by gesture would be. I probably don't know. I don't want to know. Or any other form that isn't libel. Cool. Okay. To recover for slander, okay. You must prove either special damages or slander per se. So I'll explain what this means. So special damages. Special damages are damages that well, in this specific case, special damages means like money lost. So if you were to lose income or business because of the slander, you would have to prove how much you lost out on. So that's what special damage is. It's called special because you can't usually get money for lost income and for just economic loss, but in this one specific case, you can. Slander per se. The per se means, I actually don't know exactly what it translates to, but in my head, it means automatically. So that means that as soon as it's said, it is slander. So there's no evaluation that the court has to do on deciding whether the statement is slander. It is just, if you made this type of statement, it's automatically slander. And these are the types of statements that are slander per se. Okay. So slander per se, which means you don't have to prove special. So you don't have to prove your damages. Okay. So slander per se, it's assume that you are going, let me put this a different way. I think this is good for me too. Slander per se means you're assuming that it harmed you already. So if it's one of these types of statements, then no one has to think about like whether you suffered harm to your reputation. It's automatically assumed. So I think it'll make sense. So committing a crime. So if someone says you committed a crime, certain types of crime, probably more severe ones, that's automatically assumed to harm your reputation. Okay, I gotta get these down. So committing a crime, conduct reflecting unfit for business, having a loathsome disease. The examples they use are, so if you say someone has leprosy or an STD, don't go around saying someone has an STD. That is slander. Okay. And sexual misconduct is, I guess, slander. Okay. I have to remember to not get so in the weeds. And if you're watching, definitely let me know if, well, I don't really need you. Just say hi. I don't really need you to let me know anything because I'm just learning here. Okay. Parasitic damages, those are emotional damages, I believe, that are attached to physical injury. I'm not going to worry about that. Not going to worry about this. Okay. If the plaintiff, oh my God, I just did this. If the plaintiff is a private figure, public concern. All right. Let me go over. So libel is written, printed, or otherwise recorded. You get general damages for harm to reputation. Slander is spoken, gesture, anything that's not libel. You have to either prove your damages, so you have to prove the harm to your reputation, or the statement has to be in one of these 4 categories. It has to be either about committing a crime, being unfit to like do business, you have a loathsome disease, or something, or sexual misconduct. And if it falls into one of those 4, then you don't have to prove the harm to your reputation. It's just assumed that because those things are so bad that they did harm your reputation. Okay. Sorry, if you hear me talking like a robot, it's because I'm literally like looking up like a crack in my ceiling away from my screen and saying it out loud just to test my memory. Okay. Now let's talk about what defenses to slander. So if someone sues you for slander, how are you going to get over it? Or if someone sues you rather for defamation. So defamation defenses. I feel like a bunch of YouTubers could benefit from this knowledge. Okay. So a truthful statement is not defamatory. So, okay, truth is just like a total bar. So if it's true, it's not defamatory, no matter what. So truth is a total bar. So got it. If it's true, then it is not defamatory. Okay, what if it's mostly true? Mostly true is generally not defamatory. Okay. Even if some details are inaccurate. So you can get away with a few little bit of lies, apparently, if most of it's true. All right, I think that's it. Okay, interesting. If it's true, you might be able to sue for intentional infliction. Oh, I feel like I should not be giving the interrupts this information. Emotional distress or invasion of privacy. Oh, I forgot I have to still do invasion of privacy. Okay. So if it's true, it's not defamatory. So that's defense, but you still could be on the hook for IIED, which is intentional infliction of emotional distress, and invasion of privacy. Okay. So I feel like we have went over this, blah, 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 blah. If it's No, I'm not going to write that again. Okay. Another defense is consent. Okay. So if the plaintiff consented for you to publish that statement, then there's nothing to be sued for. Okay. If you have absolute privilege, and privilege means, like in law speak, like privilege means you're allowed to do something. So you have like, you have the ability to defame or say defamatory, well, you wouldn't be saying these types of statements. You cannot be sued for defamation if it is in the midst of judicial proceedings, legislative proceedings. Legislative proceedings are ones that happen like in Senate and like Congress. Legislative duties. If it's said between spouses, okay. So if you're telling it to your spouse, that's why you can tell your spouse all the secrets, Again, this is totally not legal advice. Being a little unserious right now, but this part is serious, that between spouses. It's not defamation. And if you're required to publicize it. So like if a newspaper is going to publish like at someone's speech, or a TV station is going to broadcast like someone's speech, maybe the person speaking might get in trouble, but they don't want this news station to get in trouble if they have to show it. Okay. Now, oh, okay, some statements. Sorry, I was reading a little bit. I'm still here. Okay, so I have to Google something. Sorry. Let me look this up really quick. What is conditional privilege versus absolute privilege? What does that mean? Conditional partial. Plaintiff proves the speaker acted with actual malice. Okay, got it. Oh my goodness. Okay. I was doing a lot of reading. Got it. Okay. Absolute privilege means you are 100% not, so you're 100% safe, basically. Okay. Now, this is what I was looking up. There's something called qualified privilege. And this it requires actual malice. Okay. And that's statements that are made in the interest of the defendant. And when interest just means like for the benefit of, in the interest of the recipient or a third party, or affects important public interest. Or, okay, got it. Okay, a qualified privilege. Okay, this requires actual express malice. All right, now I think I understand it. Um, got it. Okay, so let me review that was like a kind of a sprint for my brain. And sorry, I don't know what it's like listening to this, but let me go through the defamation defenses because now I think I have it organized. So one effective defense is truth. Um, Another one is consent, if the person consented to you publishing the linked statement. And then the affirmative defense, and an affirmative defense is when you say, yeah, I did it, but like I had these good reasons, so I'm not actually I shouldn't be held responsible. So affirmative defense, you some cases have absolute privilege, like things made in judicial and legislative proceedings, legislative duties, statements made between spouses, and by publishers who had to publish it. Like they were required to, like by law, to publish the statement. Um, in those situations, absolutely not defamatory. Um, there's other situations where you might be protected, but if you made it with express or actual malice, meaning like bad, like ill will, then you could be liable. Those situations are ones that are made in the interest of your own reputation, in the interest of the reputation of the person receiving the information or a third party, or if it affects public interest. Got it. Okay. Okay. Invasion of privacy is next. Let me see how long this is. Can I do this? Ooh, yeah. All right, I think this is going to maybe be less painful than defamation, but now you can see why people are like, oh, defamation cases are hard to bring because holy crap, I have to still go back and look back over that. And I don't even really remember getting to defamation in my first year law school class, in my first year torts class. Okay, let's talk about invasion of privacy. I think this is another one that YouTubers will probably be interested in because it comes up so much. Okay. Invasion of privacy. And if you're liking this, please make sure you like and subscribe or comment. I figure it's nice background listening, so definitely make sure if you have anyone who would be interested to let them know about this. So invasion of privacy, okay, invasion of privacy happens in four ways. Four ways. So one, misappropriation of the right to publicity. And from what I remember, because I kind of already went through this, that is like your name and like the use of your name and likeness. Intrusion upon seclusion is probably what it sounds like if someone intrudes upon an area that you think you're like private. Placing plaintiff in a false light, and public disclosure of private facts. Okay, I'm gonna look away from the screen and make sure I remember the four causes of action, which just means like reasons you could sue for invasion of privacy. Misappropriation of right to publicity, intrusion upon seclusion, false light, placing the plaintiff in a false light, and public disclosure of private facts. Okay. The right of privacy does not extend to corporations, so no businesses can, well, that makes sense, because then you would just say it's like stealing your trade secrets or something. But okay, right of privacy does not extend to corporations, and you do not have right of privacy if you are dead. Okay. Let me remember the four again. It is right to misappropriation of right to publicity. It is intrusion upon seclusion, public disclosure of private facts, and placing the plaintiff in a false light. Okay, so let's talk about misappropriation of the right to publicity. So most states, you can bring this. So that tells me that in some states, you can't. Okay, so this is the right to control commercial use of identity. So there are things you have to, well, sorry, I was taking a coffee drink. Okay, to prove that someone is liable for misappropriation of the right to publicity, you have to prove unauthorized appropriation of name, likeness. Well, let me just do this: name, likeness, identity. This to be for the defendant's advantage. Without consent, but that's what unauthorized means. So why did they say that? Okay, without consent. Excuse me. And damage. Plaintiff suffers damages. And here damages would just be like, well, it could be, I guess I'm not, well, we'll see what it could be, but I'm thinking right now, the one thing I know it could be is like harm to your reputation. Okay. Apparently, the states are split on whether you have the right of privacy after death. Interesting. Some states say that you can pass on your right to privacy. Oh, Olap. Are you here, Olap? I don't know if you're here. Oh, Kookie, you're here. Oh, Violets. Oh my gosh. Hey, Kookie. I wasn't even looking at the comments. When they're talking about the right to privacy after death, I was thinking about Beth B. Oh my gosh. Oh, I wonder if Texas does right of privacy for dead people. I'm gonna look that up. Hi, Olaf. Right of privacy on death. No. Oh, that's so sad. Oh, that is very sad. Be me. Wow, that's rude. Texas does not have a right of privacy. So actually, it's possible. Oh no. Okay, again, this is not legal advice. Not legal advice, but possible that if someone were to steal someone's dead person's cell phone, that maybe that's okay because they don't have a right to privacy because they're dead. That's crazy. Oh, hi, Owl Violets. I'm happy to hear you and see you. Well, I'm happy you hear me. Okay. Where was I? Wow. Whew. That's like adrenaline. Okay. So yeah, that makes sense. So if you use the person's name, likeness, or identity for your advantage without their consent, that's no good. Okay. Intrusion upon seclusion. Many states recognize unreasonable intrusion upon private affairs. Okay. So to prove someone intruded upon your seclusion, you have to prove they intentionally intruded, physically or otherwise, into private affairs, solitude, or seclusion. And the intrusion has to be highly offensive to a reasonable person. And you'll probably, if you like keep watching me, you'll see me bring up a reasonable person over and over and over again. That's You probably notice it if you follow crime stuff, or just legal stuff. But yeah, a lot of, especially in torts, when you're suing someone for harming you, a lot of it is judged by what would a reasonable person would do. Okay, so some examples of unreasonable intrusion. Eavesdropping on private conversations by electronic devices is unreasonable. Um, Taking a picture of a person in a place is not unreasonable usually, unless it reveals private information the person meant to keep private in a public place. Okay, so usually, so I'm guessing like I don't know what that would be, but um maybe like an upskirt photo. I could see that being an intrusion upon seclusion, maybe. Okay. Um, what does it mean to place the plaintiff in a false light? You have to, okay, make public facts. That's not helpful at all. Well, facts that create false lights and highly offensive to a reasonable person. And most jurisdictions, I'm just gonna put JX if you like, JX just means jurisdictions. It's just too long to try to write. Most jurisdictions require actual malice. Okay. So, so saying that a plaintiff holds a view the plaintiff does not hold, that could be placing the plaintiff in a false light. So someone calls me a snowflake. Does that mean that they are placing me in a false light? I think so. Um, well, I mean, I am a snowflake, but I'm not a snowflake. Um, or if you say someone did something they didn't do, but it has to be something, the thing is, it has to be something that's highly offensive. So it's not just any public fact. It has to be something that's highly offensive. So I think that's a good point. Um, it doesn't have to be totally false. It could be like misleading. So truth, well, yeah, okay. So let's talk about what publicity. Okay, so the last one here, public disclosure of private facts. What does that mean? It's exactly what it sounds like. It seems like they gave publicity to a private matter in a person's life that was highly offensive and not a legitimate concern. Gave publicity to private matter in one's life that is not matter of legit public concern. Ooh, I can feel that I'm running out of steam already. Okay. This is one that I apparently, oh, this is disfavored, which means not often sued for, because it collides with the First Amendment freedom of speech. Okay, a little bit more, and then I think I am going to take a break, and I might be on later. I do still have more to do. Okay, the last thing, what can you get for invasion of privacy? You can get damages for emotional distress and mental distress. Well, you have to prove emotional distress to collect. And what are defenses? the privileges that I was talking about earlier. So the absolute privileges, like statements made in court and legislative hearings, and then ones that are made for specific purposes. And consent, if the person consented to you intruding upon their seclusion. Okay. Before I go, I'm going to go back to defamation because I am just very annoyed that they made it so confusing to go over. So, okay, I'm going to go back over this. Okay, I get what defamation is, but it's the public-private parts that are confusing me. Okay, so if it's a private person, public concern, okay, so if the statement is made about a public matter or about a public person, then you have to prove the statement is false. Okay, so if it's public matter or public person, it has to be proven false. And if it's, right? Okay, I'm gonna have to come back to this, I think. But thanks guys for hanging out with me. I'm really glad that some of you stopped by. I might go live later. Well, I don't know how fried my brain is. I'm gonna take a little break. Maybe go watch one of Olap's videos. And then might be back on later. But thanks again for joining and hanging out. I hope this was interesting and maybe you learned a little bit. Thanks, guys. I hope you have a good rest of your evening, and I'll see you tomorrow probably if I don't see you tonight. Bye, Olap. Bye.